The state has rested its case in chief, and I understand that the defense has a motion that likes to be heard at this time.
Your Honor.
Yes, sir.
Have we identified all the exhibits that have been identified but not admitted, Your Honor?
We have, and me and Dana's lists are consistent with each other.
Okay.
If anybody wants to look at the list, y'all are welcome to do so.
Thank you, Your Honor. May I proceed, Your Honor?
You may.
As to the motion for directed verdict, the state defendant on behalf, counsel for the defendant moves for directed verdict and for the court to discharge him, and in support of it provide the following. First of all, Your Honor, the state has charged the crime of capital murder, kidnapping. This court knows kidnapping has two basic components. Either there's some type of asportation that someone is taken and they move without their will, or the second part is whether or not someone is inveigled, and that is basically under case law, and I think in the statute, a luring, trickery, or a threat, proof along those lines. So it's clear that the state has not placed in the record any proof whatsoever for the jury to consider that Mr. Lee was held against his will and transported, or there's no proof of asportation of Mr. Lee to any other location. So that puts us down to the inveiglement. There's no evidence whatsoever there was any trick associated, or they haven't advanced any proof that there was any trick associated with any conduct on part of Mr. Herrington, whereby he was tricked into coming to a location where Mr. Herrington was and kidnapped and held against his will at that time. Second, Your Honor, as to the threat, it's clear in the record that all the witnesses for the state, investigating witnesses, Chief, as well as Baker and Fortner, none of those three witnesses advanced any proof whatsoever that he was threatened in any way, or there was a threat placed against Mr. Lee that something was going to happen to somebody else if he failed to come to the location where Mr. Lee was. Now we're down to the last aspect of embezzlement, which is the luring aspect, Your Honor. Basically what we've heard in the courtroom today is a summary or an interpretation of one statement, subject to multiple interpretations, as testified to by Detective Baker. In his own testimony, Your Honor, he stated it's open for anybody's interpretation as to exactly what they were talking about. That's what Detective Baker testified to. The Chief testified that basically one word in the statement pertaining to what was going to occur before he was going to go back to block is the evidence of embezzlement, that there was a luring based on that particular statement. Your Honor, the evidence does not support that beyond a reasonable doubt that a jury could find that there was any luring by my client if you take the state's testimony most favorable to the state and give them the benefit of any and all evidence most favorable to the state. Additional argument as to the motion for directed verdict, Your Honor, pertains to the quality of the evidence that was placed into the record. The notice was filed on 11/5/24 pertaining to the 902.11c objections. The notice was filed, the objections were filed on 11/19/24. Your Honor, within that time frame, the court knows certain things were supposed to happen. The state at that time was required by law and required by the rule and the case law that they were supposed to set this matter for hearing, and the court was to rule on whether or not the objections were valid and whether or not the evidence that was in the notice would be admitted into evidence. The only piece of evidence that the state should be able to advance as to the 902.11c would have been one video. If the court had granted the state's objections based on the rule of court. And I'll state exactly how it goes, Your Honor. An adverse party waives any objection that is not specifically stated in writing, which we did, served within 15 days after receiving the notice required under paragraph B, or at a later time that the party has agreed on. That did not occur. The proponent must schedule a hearing on any objections, and the court should determine the admissibility of the record before the trial or hearing at which it may be offered. If the court cannot do so, the record is not self-authenticating under this particular paragraph. The court made a ruling, Your Honor, that basically two things occurred. The court made a determination that there was sufficient indicia of reliability for these particular documents, Your Honor. That is not in the rule. That is not the mechanism by which the rule authorizes the introduction of these particular documents. The court also made a determination on the record that the court was familiar with the locations within Lafayette County, and that due to that, part of the ruling included, due to the fact the court was familiar with those particular locations, certain pieces of evidence that included the videos of Jay Lee's car traveling throughout Lafayette County in different places and showing Jay Lee leaving his apartment, things of that nature were allowed into evidence. Your Honor, the defendant respectfully submits to the court that that was error and those matters should have been excluded, and at the conclusion now where we are of the state's evidence, that there was not sufficient evidence, value of the evidence is not sufficient for this case to go forward on murder, capital murder, or any other charge, Your Honor. Now, getting to the last argument. The defendant filed a motion to dismiss this case on a defective indictment. Document 98. 12/2 of this year in chambers before voir dire. A hearing was had wherein the court, without advancement by the state, ordered that the indictment be amended. To this date, Your Honor, that indictment has not been amended by any order, not on the file, and the state's rested. There's no order amending this indictment, although unprompted by motion, there was an order that the indictment should be amended. Unfortunately for the state, they've rested without an order being on file, amending the indictment. We move forward on a defective indictment. The state has closed their evidence, and directed verdict should be advanced. Our motion for a directed verdict should be granted based on the procedure that's taking place in this file, Your Honor. I checked a few moments ago. I had Mr. Dagnall check. No order's been entered amending the indictment, and therefore, that part, in addition to all the other portions of the motion for directed verdict, taken as a whole, quality and quantity of the evidence presented here today, the fact that the order amending the indictment has not been placed in the court file signed by the court, in addition to the fact that the state has failed to make a prima facie showing that a jury should consider the luring aspect of the embezzlement. And additionally, Your Honor, if you recall the testimony of Chief McCutcheon, he said that there was a time frame of 6 o'clock to 7:28, time frame by which he anticipated that Mr. J. Lee, between that time, died. There's absolutely no proof of a death. The element of luring is insufficient as presented to the jury. The 902.11d requirements were not followed, and the introduction of those tapes should be stricken at this time, removed from the record, and furthermore, Your Honor, no amendment to the indictment has been placed in the file. Hence, we went forth on a defective indictment, and this matter should be dismissed by motion, granting the motion for directed verdict.
All right, anything else?
That's all.
I'll hear from the state.